Mackenzie Shirilla is facing a life sentence for the murders of her boyfriend and his friend. Now, after speaking on camera for the first time in the Netflix documentary The Crash, her lawyers are begging the Ohio Supreme Court to give her a new shot. I'll take you inside their argument and whether or not the new doc that's got everyone talking could play a role in all of this. I'm Angenette Levy, and this is Crime Fix. Mackenzie Shirilla is making a big play, a Hail Mary, really. The convicted double murderer is asking Ohio Supreme Court to hear her appeal. This after a lower court ruled her attorney dropped the ball on her appeal, literally filing a day late. And with all of this buzz surrounding the Netflix documentary The Crash, Mackenzie may think she has a shot. I am not so sure. I'll dig into the legal part of this shortly, but first, let's look at how we got to this point. It was July 30th, 2022. Mackenzie and her boyfriend, Dominic Russo, went to a graduation party, then to a friend's house for a sleepover. Dominic's friend, Davion Flanagan, was also there. The three left in Mackenzie's Toyota Camry, and Mackenzie was behind the wheel. They were driving down the road. It was around 5:30 a.m., and then this.
Duty.
Radio. This car's split in two. Radio, there's an occupant inside. Send us a squad now. We gotta bust the window out. Send us some more units.
Any more units to progress now, Anita?
Now!
What are we doing?
31, spawn up. 60 on Westwood, on the 3 on Alameda.
This is not a fresh accident either. She's been here for a while. Radio, we got at least 2 occupants in here. No one's moving. Oh my God. Oh my God. Times 3, guys. Radio, 3 occupants. No one's conscious. No one's breathing. Bust that window out. Rookie. Oh my God, dude. Dave, what did they tell you?
Nothing.
Okay, she was life flighted here.
Yeah, I wouldn't know that.
Okay. No. You want to sit down? Wait to say this. Progress in Alameda, car into a building. 2 are deceased in the vehicle. Daughter's driving.
Who died?
I don't know whether, but there's one that we don't know. His name's Jacob. Does anyone know a Jacob?
Dom?
No, stop. Let him talk.
Guys, I know, we've been dealing with this. Your daughter's okay. She's talking to us. All right, I got to talk to you one more time. Let's let you know where we stand as a police department, okay? Where we stand today, okay? Full transparency here. There's drugs in the car. She had a bag of mushrooms on her and a scale. Full transparency, guys. I'm sorry, I'm ripping the Band-Aid off, okay? Drugs in the car. It's a mess, okay? We're not going to do anything with the blood draw or anything here, but it will probably be subpoenaed, just so you guys know. They're going to subpoena for a blood draw for the sample. Okay? Since she's unconscious, I really will, if you guys could talk, if she wakes up, we need a name of that passenger, okay?
Wait, you don't know what it is?
We don't. All I know is his name is Jacob. That's it.
Where were people in the car?
She was driving, one in the back seat, and Jacob was in the front. Davion in the back. You're the parent. I mean, you have the right to know. This is serious. And me and him were the first ones on scene to discover.
So she was awake but not awake, so she was like not
In and out of consciousness. She had to be fully extracted from the vehicle by FD. I know she has a severe leg injury. But like I said, she was speaking. She was speaking, okay? And she had her seatbelt on. Yes. We had to cut it off to get her out.
Stop.
Yeah, that probably saved her life. 100% saved her life.
She had a seatbelt on. Oh.
I don't believe the others did.
Oh my god. Oh my god. She got it out.
It was at Progress in Alameda. Like I said, they hit a building at a very high speed.
She had it on
She did not hit another vehicle.
The
It
girls
just,
were on her, or like on a person, or just on her? Or did somebody else's? Could it be that she?
that person.
What does that mean? They were
Pockets. Yeah. Yeah. That's the least your worries at this point, guys.
Oh yeah.
All right.
Well, I'm just trying to gather information. I'm an information gatherer.
Yes. I'm just giving you what I know, okay?
That was the moment Mackenzie Shirilla's car slammed into a brick wall at nearly 100 miles per hour. 2 young men were killed. Shirilla survived. Prosecutors said she intentionally drove into that wall, killing Dominic Russo and their friend Davion Flanagan. Shirilla opted for a bench trial, no jury, and the judge who heard her case found her guilty on 2 counts of murder and sentenced her.
There's a very good likelihood, Mackenzie, that you will spend the rest of your life in prison. That won't be up to me. That will be up to the parole board, and that will be up to you to a great extent. I understand that the pain in this room wants me to impose the harshest sentence, but I don't believe that would be the appropriate sentence, because I do believe that Mackenzie will not be out in 15 years. So she's sentenced on count 2, the murder of Davion Flanagan, 15 years to life. She's sentenced on count 1, the murder of Dominic Russo, 15 years to life, to be served concurrent to each other with credit for time served.
But now, Shirilla is fighting back. Her legal team has taken her case to the Ohio Supreme Court, arguing a technicality so small it comes down to 1 day and a leap year. The filing is hitting the headlines just weeks after Netflix released The Crash, her first on-camera interview since this all happened. So what does the documentary have to do with the appeal? And could it actually hurt her case? Shirilla has always maintained that this was an accident, that she blacked out, and her family pointed to a medical condition called POTS, but her lawyer never called a medical expert to testify about it, so that claim has never been substantiated in court. Now back to this new appeal. Shirilla's lawyers filed this appeal with the Ohio Supreme Court on April 27th. They're basically asking the court to hear this, and the court has not decided whether or not they will. The whole thing comes down to a calendar. Here's why. Under Ohio law, a convicted defendant has 365 days after their trial transcript is filed to challenge their conviction. Shirilla's trial transcript was filed on October 24th, 2023. Her lawyers filed their post-conviction relief petition on October 24th, 2024. That is 366 days later, 1 day past the deadline. So how did that happen? Her lawyers say they missed the deadline because they didn't account for 2024 being a leap year. February 29th, that extra day, they say, threw off their calculation. But here's the thing, the appeals court did not buy it. A judge wrote that Ohio law is clear. You have 365 days, not the 1-year anniversary. A leap year does not change that. Now there's another layer to this appeal. Her legal team is also saying in this appeal that her lawyer did not investigate that medical condition, POTS, which can cause blackouts. They say if he had, she might have been acquitted. There is medical evidence that Mackenzie Shirilla suffered from a pre-existing medical condition that could have caused her to black out while driving. Now Shirilla is taking her case to the Ohio Supreme Court. Her lawyers argue that if the clock had started later, based on a different transcript, her filing would have been early, not late. Here's why that matters. Shirilla's case started in juvenile court. A judge there held a hearing to decide whether to move her to adult court. Her lawyers say that judge should have never moved her case at all, and they made that the first issue in their direct appeal. But the transcript from that juvenile hearing was not filed until December 15th, 2023, nearly 2 months after the trial transcript. Shirilla's lawyers say the 365-day clock should have started on December 15th, not October 24th, and they point to something in the record to back themselves up. The juvenile transcript was cited repeatedly by the defense. The prosecution's brief of appellee similarly cited the juvenile transcript, and the ensuing decision and the original appeal discussed the evidence presented at the bind-over hearing, saying both sides used it. So her lawyers argue it should count as the starting line. The appeals court said no. The law says trial transcript, not every transcript from every hearing. Now Shirilla's lawyers want the Ohio Supreme Court to settle the fight. And they have another argument too. Even if she missed the deadline, they say the court should still hear her case because the stakes are so high. The appeal puts it this way. When a petition provides substantial reason to believe that the defendant would be acquitted at a new trial, principles of equitable tolling may be exercised to excuse the late filing. Which brings us to the Netflix documentary. In the crash, Shirilla finally speaks on camera for the first time, and she tries to explain what happened that night. She says, I remember turning on the street, and then I'm waking up in the hospital the next day, and my whole life is shattered. When asked about her relationship with Dominic, she says, we would have probably been married by now. It was rocky, but it was good. We were in love. But here is the moment everyone is talking about at the very end of the documentary. The filmmakers reveal that her lawyer was in the room the entire time, and you see her demeanor shift. She checks in with him, asks how she is coming across. Then she turns back to the camera and says, I'm big on the no intent. There was no intent whatsoever there. So here's a question. Is the documentary part of the legal strategy? Does it help her case with the Supreme Court, or could it actually hurt her? So to discuss all of this, I'd like to bring in Diane Menashe. She is a criminal defense attorney in Ohio. She has represented a number of high-profile clients. Diane, I know you've been following this, the case. What are your thoughts on Mackenzie Shirilla going to the Ohio Supreme Court and saying, hey, please take my appeal, hear my appeal?
Yeah, well, I think the latest effort in April is, their post-conviction petition was denied because they missed the deadline, and now they're kind of, asking the court to make an exception for them. I think they have little to no shot in getting relief with respect to that. I mean, they just missed the deadline. It's as simple as that.
They did miss the deadline by 1 day, which seems really absurd to me. I can't believe that. I can't believe that your deadline is coming. You don't even file for an extension, and you file a day late. It's so like junior high. That's what's so shocking to me, because your client is up against it and needs your help, and then you come up with this, oh, but there's a leap year and all of this silliness. And it seems to me, from what the prosecutor is saying, that the statute is quite clear. You have 365 days. You have a year.
It couldn't be more clear. And I think the other thing that makes it look just, if you will, messy and last minute is some of the affidavits attached to the PC petition were notarized that same day of the filing. So this is clearly, waiting to the last minute, the last hour. And to your point, appellate attorneys, their whole job is literally to keep track of deadlines. I mean, that is the job of an appellate attorney, to know when things are to be filed. If you can't meet filing deadlines, file motions for extension, and meet the deadline, because the deadlines are just that. They're deadlines. Yeah.
Right. But courts are often flexible. So I've seen a number of times in a number of cases where an attorney will go to an appeals court, to an appellate court, and say, can we have an extension of 30 days or 60 days? And they always grant those. It's pretty rare that they wouldn't give you an extension.
Well, but I think the key there is going proactively before the deadline has passed, right?
Right.
I don't think I agree with you. I think that's true of appellate courts. I think that's true of trial courts. In particularly situations where you go to opposing counsel and say, would you be on board with an extension? And if I get an extra 14 days, I'm happy to give, the government an extra 14 as well. And then go to the court. I couldn't agree more, but the key is that you have to do that proactively and not once the deadline is passed.
Another thing that is so shocking to me is the fact that I think Mackenzie Shirilla, because of her desire to be a TikToker, because of her desire to be an influencer, all of this stuff, I really think she thought doing this Netflix documentary was going to help her cause. And I'm sure her attorneys thought, oh, we'll do this, you can do this, and then I'll appeal to the Ohio Supreme Court, which the Ohio Supreme Court has to actually say, yes, we'll hear it. I think with the current makeup of the court, they're going to be like, yeah, take it somewhere else. We're not interested. But I think they thought this would be helpful. And I don't think it is helpful because I don't think she looks good at all.
You have to assume that they thought it would be helpful because we clearly see at the end of the documentary that she's in the room with her defense attorney when she's doing making the interview. But it is hard to imagine how they would think this is helpful, particularly because we can presume they'd spent a lot of time with her, one-on-one before. She doesn't present well. I mean, she just doesn't. And if we're to assume that she presented that way after, being prepped, well, that's concerning as well. But I couldn't agree more. It's hard to understand the strategic play here. Any attorney that spends time with their client, knows how they will present, and it's hard to imagine her attorneys thought she'd present well.
Judge Russo basically said to her during sentencing, "You're more than likely going to be in prison for the rest of your life." I mean, she told her that. I mean, because she's eligible for parole in 2037. That's going to be her first go around with the parole board. They're not going to this is Ohio. They're not going to let her out on her first go around. It would be very unlikely. And if she gets out on her second go around, she would have to show some incredible strides that she has made.
Well, and I do a lot of parole work, for high-level murder cases here in Ohio. And I have to tell you that now another way that the documentary has hurt her is that the parole board will not only be made aware of the documentary, but most specifically is her lack of remorse. And here in Ohio, as the parole board is considering release, which will be for the first time after she serves 15 full years, they don't just look at her institutional record. Does she have conduct write-ups? Does she have institutional employment? But really, the parole board in Ohio is looking most notably at that remorse piece and acceptance of responsibility. Now, although she certainly has a right to a fair trial and a right to have a trial, I can tell you from my experience, those that enter pleas and don't go to a trial, the parole board always looks more favorably towards releasing them because they've accepted responsibility. But here we not only have someone that went to trial, but now we have someone that's been convicted and is continuing the narrative that she is innocent. And even if that is true, I will just tell you, the parole board will use her lack of remorse and lack of acceptance of responsibility in this documentary against her.
Another thing that I saw when the prosecutor O'Malley up in Cuyahoga County, he wrote that the Supreme Court should not take this up. They should just ignore it. He said that a lot of the arguments that her defense attorney was making in their briefing were federal arguments for habeas relief and things of that nature. Do you see them trying to go the habeas route, and would that be successful?
I think that I mean, who knows what they'll do. I think they're going to do everything they possibly can at this point, particularly since the optics of her appellate counsel missed the deadline. So I can tell you just from a representation standpoint, that attorney is going to keep trying to get in, if you will. But I think, the best route was the direct appeal. They lost that. As we know, that's really where, if you have a chance, that's where it is. And so I think kind of, as they move forward, they're going to be trying to seek relief, but the chance is only slim. They don't get greater as time moves on.
No doubt, no doubt.
Yeah.
The cards are stacked against her, and it just seems like at every step, at every point, Mackenzie Shirilla makes a decision that makes it worse for her and not better.
It does seem that way, and particularly lately, it seems like a series of bad decisions have been made. Yeah, yeah, and unfortunately, she's has counsel. So but that said, sometimes clients do what they want. You can certainly take them to water, and you can't make them drink, and I understand that as well. But yeah, she's made some bad decisions, particularly as of late.
No doubt. Well,
Yeah.
Diane Menashe, I really appreciate your time. Thank you so much.
Thank you for having me.
The Cuyahoga County prosecutor has filed an objection to Mackenzie Shirilla's case being heard with the Ohio Supreme Court. They have asked the Ohio Supreme Court not to hear this case. And that's it for this episode of Crime Fix. I'm Angenette Levy. Thanks so much for being with me. I'll see you back here next time.